All right, so you each have 20 minutes. These arguments are being live streamed so the public can view them. So Ms. Kaufman, I appreciate you being on the phone. We can also view you, I guess. And how much time does the appellant wish to reserve for rebuttal?
I'd like to reserve 10 minutes, sir.
Okay, you may proceed.
Good morning. May it please the court. My name is Paula Kaufman. I represent the appellant, Mr. Gordon. This appeal arises out of the disposition of a motion for enforcement of an equitable distribution in a final judgment of dissolution. In 2009, the former husband was required to deed the marital property to the former wife. As part of that equitable distribution, the former wife was supposed to sell the property and pay the former husband $151,000, or approximately 25% of the value of the property in 2009. Both parties and the court contemplated that the former wife would sell the home in time for one of their two minor children to take advantage of a prepaid college tuition program in Virginia. In fact, the final judgment provides that the former husband had implicitly agreed to that relocation. 8 years later, in 2017, when it became glaringly apparent that the wife had no intention of selling the property to move to Virginia for either of the children to attend college, a very patient former husband filed a motion to enforce the final judgment. The request was either that the property be sold, that the line of credit be paid off, that the former husband's name be removed from the equity line of credit, and that the $151,000 that had been owed for 8 years be paid. At the May hearing that resulted in the order of the lower court, there was reference made to a March hearing where at least the former husband and his counsel believed that the May hearing had been set to discuss how the enforcement was to be accomplished. However, by the end of the May hearing, there was foreshadowing of an appeal by the losing party. The court reserved ruling, and truly, it was not clear how this was going to turn out until the order was entered. Ultimately, the trial court found the language in the final judgment concerning payment of the $151,000 to be unambiguous, and also concluded that the court had no authority to force the sale of the property because of homestead immunity.
Now, you're claiming that that language was ambiguous, that there was an ambiguity.
Yes, that's one of the things that we are claiming.
Is there a different standard between an ambiguity between a judgment and a contract, let's say a settlement agreement?
I think that opposing counsel would say there is, yes. We maintain that the final judgment does contemplate a sale date, that it be sold, and it's not if, it's when. So
but if there is an ambiguity, how does that ambiguity get resolved? Are you asking for extrinsic or parole evidence to come in? And if so, who would provide that evidence if it's a judgment? You going to call the judge to testify?
Actually, we can look at the record itself, and I would do that at this time if I can refer the court to pages 4, 5, and 6 of the reply brief. At the hearing in 2009, counsel for the former wife indicated they were not requesting title to the property. They only wanted sole possession of the property until the move to Virginia for the children to go to college. At that time, the former wife wanted the former husband to continue to be responsible for the house he owned, not just half of the mortgage, in which she requested to be permitted to continue to reside in until it was sold. As justification, counsel argued at that time that the former husband would receive the benefit of half the proceeds when the house was sold. So there was no logical reason why he shouldn't be responsible for paying half of the expenses.
Well, these might have been arguments that the parties made, but they couldn't agree on anything, right? So the judge entered her own final judgment. So how does that, how are their arguments before that relevant to enforcing this judgment?
I believe it was Judge Fleming. It was not the same judge as the judge who rendered the order under review. Okay. I also, as far as extrinsic evidence available from the record that Judge Fleming would have been considering at the time he tried to do justice in this case, the former wife actually testified in the trial that she wanted to relocate to Virginia. She said possibly after the older daughter, who was just a few years from graduation, possibly after the older daughter graduated from high school. There was a relevancy objection to that testimony. So apparently at that time, the former husband did not want that testimony, but it did come in. And the former wife was permitted to explain that both families resided in Virginia. The prepaid education program for Virginia universities had been purchased for both children. It cost $300 a month for that. She had borne the expense since the parties became separated a little more than 2 years before the hearing. And the former wife at that time requested that the programs be ordered by the court to be maintained for the benefit of the children. In fact, she wanted the former husband to be responsible for back payments totaling more than $8,500. I would suggest that that certainly indicates her intention at the time to relocate and sell the house. Rachel was born in 93.
How is that consistent with the court's ruling that they are to attend, was it Windermere, all through high school? How is that consistent? Didn't the judge say both children shall complete high school at whatever the private school was?
It would be inconsistent with respect to the younger child, yes. Presumably the older child would have graduated from the designated high school. The children were only 16 and 10 at the time the judgment was entered. There has been an argument that the former husband was too patient in this case and in fact missed some deadlines and now has to live with the order under review. In fact, the timing of this motion to enforce the judgment was when it became abundantly clear that neither child was going to go to college in Virginia. We have argued in our briefs that the final judgment, if ambiguous, requires a reasonable deadline for the sale. I would suggest that more than a decade after the final judgment has been entered is more than a reasonable deadline. We have also argued that extrinsic evidence is appropriate. There's a latent ambiguity, and I'm relying heavily this morning on the Rule Act decision. This was a decision that did not exist at the time we wrote the initial brief. That case stands for the proposition that where the terms of a final judgment are ambiguous as applied to facts developing after the final judgment, the court may modify what is implicit in the final judgment and enforce that order. And I don't know whether it matters, but my screen has changed. I'm seeing myself and opposing counsel. Is there an issue on the court's end?
No, you can continue. We can see you fine. We can hear you fine.
Okay. There you are, Judge. In that case, the final judgment indicated that the residence at issue was marital property. In that case, the final judgment permitted the court to retain jurisdiction to clarify the order that had been entered. In the Rule Act case, the former husband transferred the home by quitclaim deed to his brother, and he shouldn't have. The judge said the former wife this is the trial judge in the Rulak case. The judge said the former wife has no legal interest in the property, only a legal interest in compensation. That's true for us as well, by virtue of the final judgment requiring that the former husband relinquish his property interest in that property. I believe it was within 10 days of entry of the judgment, and if he didn't do it by operation of law, he was going to lose his ownership interest. The judgment in Rulak was silent as to the financial interest. Basically, it meant one of the parties had no interest at all. That is exactly what.
Counsel, can you hear me?
Yes.
Did you file a notice of supplemental authority with that Rulak case?
Yes, sir, I did.
Okay.
2 days after the reply brief, Judge.
All right. Thank you.
On appeal, the court found that the final judgment, although saying that the property was marital property, that judgment was silent as to the disposition of that property. The trial court had said the petition seeks to modify or change the final judgment, and the equitable distribution was non-modifiable. The trial court in that case also said that the time periods had expired, the time periods for a motion for rehearing on the order or for an appeal from that order. And this is very similar to some of Mr. Weissman's arguments in the instant case. Rodak holds that the final judgment silence on the marital property disposition did make that final judgment ambiguous. The judicial error in that case was the absence of specific language in that final judgment, just like what the former wife is arguing in our case, that no sale date means no sale was contemplated, and that the judicial error is that a sale date should have been given rather than couching it in terms of the contemplated when the children moved to Virginia to attend college. Significantly, one of the factors that appeared to motivate the Rodak court or the Rulak court was that the equitable distribution needed to be modifiable because the time periods for other remedies had expired, which is exactly what opposing counsel is saying in our case. In the motion for rehearing filed before the lower court in our case, it was argued after the parties saw the substance of the final judgment, it was argued that the trial judge had overlooked the reservation of jurisdiction in the final judgment to require the parties to execute all documents necessary to affect the transfer and ownership of property in the equitable distribution. Furthermore, it was argued in the motion for rehearing that the court had overlooked reservation of jurisdiction over the parties and the subject matter of the order for further action as required and permitted by law. What was sought in the motion for rehearing was authority to direct satisfaction of payment through a deduction in alimony, relinquishment of other assets, or garnishment of wages to basically take a detour around the homestead issue. It was also argued that the absence of a specific date for the sale should allow the court to determine a reasonable date, which we were arguing was 2020. The extrinsic evidence that we are relying on in this case is the trial testimony, primarily that offered by the former wife, as well as the prepaid tuition program actually referenced in the final judgment. There has been unjust enrichment here. And we also argued that an equitable lien would be necessary to overcome that impediment.
If the
Now-
final judgment, though, was inconsistent with the testimony, wouldn't the time to have addressed that been in a motion for a hearing?
The final judgment was inconsistent with the trial testimony, and I'm sorry, I didn't catch the rest of that.
Then wouldn't the time to have addressed that been by motion for rehearing?
I can't disagree with that, Judge, but under the Rule Act decision, I think this court could find that it wasn't addressed, and because basically the former husband has no other remedy at this point, justice would dictate that this ruling be reversed. I do want to point out, with respect to Mr. Weissman's argument that there was something inappropriate about the motion for rehearing, the court did not find the motion for rehearing to be procedurally barred in any way. It wasn't untimely. The court did not find that the allegations contained in the motion were not sworn to, and therefore the court would not consider them. The exact wording of the motion, of the order on the motion for rehearing, is former husband failed to state any new issue of law or fact that would warrant a rehearing. I believe that's a merits determination.
Ms. Kaufman, just so you know, you're approaching 4 minutes left. I don't know if you want to say that time for rebuttal.
I do, Judge. Thank you.
All right, thank you. All right, for the appellee.
Benjamin Weissman, representing Deborah Gordon, the appellee, if it may please the court. I want to point out a couple of things before I get to my argument. So this Rulock case that she's citing to was filed in a notice of supplemental authority. And I think, as you've all heard, it's basically her entire argument at this point, which is improper. And you're also not supposed to
How
file.
about Kirshner?
Excuse me? Sorry, Your Honor, I didn't hear you.
How about Kirshner, the Kirshner case?
Oh, what about the Kirshner case, Your Honor? The Kirshner case is a case where we're dealing with a marital settlement agreement that's entered. And then that marital settlement agreement is being enforced. And I think Judge Harris pointed out a great point in his question. There's a huge difference between interpreting a judgment and a contract. And the reason for this is that a contract has a mutual exchange of promises and a reliance and expectancy factor on that mutual exchange. And when you don't have terms that are important but not essential included in the contract, the court will imply them because you expect that reasonable people will have it within the idea of their thought processes. But that's not how judgment construction is. Judgment construction.
Was the marital settlement agreement in Kirshner incorporated into the final judgment?
I believe it was, Your Honor.
And if so, is there a different rule that applies then as far as interpreting the contract versus the final judgment? I mean, at that time, does the marital settlement agreement have any worth on its own, or is it simply part of the final judgment?
I believe it does, because you're allowed to have the independent. You don't have to move to enforce a judgment to enforce a marital settlement agreement. You can file a contract action. You can file a breach of contract under law. So it does not get merged into the final judgment as a contract does. Because of that, that's what happens in a lot of these cases. A lot of these cases, when you read them in the appellate court, they have a party moving to enforce the settlement agreement. So I don't know if the merger doctrine exists in that circumstance. And even if it does, it doesn't. The main distinction between the two is also the fact that in Kirshner, the property was not granted to one party exclusively. And that's the issue with every case that they have to cite. There's no granting of the property to one party exclusively. There is the granting of possession of the property. So both parties still have a marital interest. And the cutoff for property rights are when property rights are adjudicated in a dissolution. Property rights are not fully adjudicated if both sides still have an interest in that property.
Are you telling us that it's really appropriate to interpret the judgment that former wife never has to pay husband as long as she never sells the house?
I think that is unfortunately what it would mean according to its literal meaning, because the parties, this is a highly litigated case. Motions for a hearing were filed on both sides, and appeals.
I got a very simple question for you. Do you really think it's appropriate to interpret the final judgment to say that former wife never has to pay the husband unless she sells the house?
I think that that's unfortunately what the literal language says.
And that she has no obligation to ever sell the house.
I believe that that's unfortunately what the language says, and the rule of finality of judgments and the certain rules that guide the general common law are more important than the individual equities in this circumstance. But there's a way to construe the provision otherwise, as the Kirchner case presents. It could be construed as a source of payment. So we're not in a position where either it has to be that's the only way they get the payment, or she can force sell the property. There is a middle ground where we construe the language as unambiguously providing that it's due on that, but it's like any other equalizing payment that he has creditor v. debtor remedies, which would be the appropriate point to raise all of the.
If it's construed as a source of income, what does that mean the result of this hearing should have been below?
The result of the hearing should have been exactly the same. That the issue for the hearing below was, does the judgment have an executory provision inside of it requiring the sale of the house? And the ruling below ultimately said there's no procedural jurisdiction over any of these nebulous claims that were not included in the first motion. And secondly, that there's no jurisdiction to force the sale of the house because there's no provision in the agreement and the judgment that requires the sale of the house. And that's ultimately what the judgment says.
But if it's construed as a source of payment, then the trial judge below is left with a situation that there's a final judgment that says the former wife owes X amount of dollars to the former husband, and she hasn't paid it yet, and so there's a motion to enforce.
Mm-hmm.
Why wouldn't the remedy be to? Are you saying the remedy is just that he gets a judgment, that's the end of it? Is that your argument?
The remedy is that he can move to modify alimony under changes of circumstances if that applies. He can file an actual action for an equitable lien if they think the circumstances require that. Something to keep in mind in this case, there were only two pieces of evidence introduced. There was a stipulation between the party that wasn't paid and the final judgment. So everything you just heard the appellant's counsel refer to in the original trial transcript was never before the trial court judge. And in fact, when the appellant's trial attorney was asked, he said he wasn't ready to go through with the evidence. He also said that he wasn't sure that if he had extrinsic evidence, if it would lead to a different result. So they didn't present the extrinsic evidence that even if it was blatantly ambiguous, they did not present that evidence to the court. So because of that, they would have waived any argument that it's blatantly ambiguous because they were required to present that. And
let me ask you this, Mr. Weissman, if I can. You're saying there's no ambiguity, right? And
I
this
don't
needs
know
to be
at all.
that there's one literal interpretation. It seems to be your argument.
Yes.
And that literal interpretation on page 13 anyway of your initial brief is that your client's required to tender this equalizing payment after the closing.
Yes.
That's the one literal interpretation you see. But in the same paragraph, you cite to three different portions that say paid to him on closing, cash to husband after resident sale, cash to husband upon sale. So we got on closing, upon sale, after sale. Just the language that you quote in your brief shows there's an ambiguity. These are three different dates. On the closing, upon the sale, after sale. Yeah, I mean, you cite an ambiguity in here and you just conclude that the only literal interpretation would be after. How do you get to that? That you're ignoring on closing and upon sale?
Well, that could be an ambiguity to those two dates, but let's go with the presumption that it is ambiguous. The way to resolve the ambiguity is to look at the legal, and this is from the Boynton case, which is pretty much the foundational case for this. You look at the legal effect of the judgment. You look at the language used. There are lots of provisions about the distribution of marital property. Every single one sets a possessor, sets a deadline, but it doesn't for the house. The rules of civil procedure and the family rules of civil procedure both require an act. If an act is going to be for performance, it has to set a deadline. This court in the Schuler case has already held that when you have a dissolution and it grants to people half interest in the profits of selling a house, but it doesn't set a deadline to sell the house, it doesn't order the sale of the house. So I think this is the middle ground that, quite frankly, the trial attorney argued himself that we construe it if it's going to be ambiguous, as just proposing a source of payment, that the equalizing payment is due. And if it is due, then it's due, this is one way to pay it, maybe the most likely way to pay it. But that doesn't mean that the judgment actually orders the forced sale, because it can't.
I think it's clear that the judgment does not specifically order the sale, but can it be contemplated that that's what the judge intended was to have this property sold? Is a judge at this point allowed to use common sense to determine what this judgment truly intended?
I don't believe so. And the reason why is you have, for example, the Wolf v. Wolf case. And in the Wolf v. Wolf case, you have a common issue that arises when one side gets possession of the property and the other side doesn't for the majority of the kids, about rental income. And when they include rental income, then they get to have that. But when they don't include rental income, then the silence is implied as a rejection. And the case law that's developed around this is that when something is necessarily raised by the pleadings and then it's not granted, it's rejected. And they filed a petition in this action. It flies in the face of why you would give someone permanent ownership of the property if it's required to be sold, when Florida statutes specify Florida statute 61. Let me get the exact quote for you. 1 second. Well, the Florida statute specifically requires, sorry, I can't find the quote in my notes at the moment. It's from the Rodriguez v. Rodriguez case in my brief, though, that if you're going to grant someone, the preferred method of granting someone the right to possess property until the kids reach majority is via granting them possession and then ordering the sale later on. And this is required by statute. The judge doesn't have to do this, but he has to make specific factual findings to deviate from that, because it's considered an unequal distribution of the equitable distribution. And those factual findings are there. There's nothing in this.
Can you assume in this case that the judge wanted the former wife to remain in the residence either until she relocated to Virginia, if that happened, or until the children reached the age of majority, pursuant to that Rodriguez case that you cite? Just so clear, the kids are now, what, 22 and 27 or something? I mean, isn't that a reasonable interpretation of why we'd allow the former wife to keep the residence without a firm sale date, is in case she does not relocate to Virginia, at least the kids have the home until they are the age of majority? Wouldn't that be an appropriate date to force a sale?
Let's say that was the interpretation of the judgment. If that was the interpretation of the judgment, then you would need to have a factual finding that the kids have reached the age of majority. There hasn't been evidentiary support for that. And there's evidence I could speak to. If we're going to speak outside of the record for equitable factors, which I don't think is proper, there's many equitable factors why she's still in the property. These would be properly raised in an unjust enrichment action or in a equitable lien. This is the problem here, is we're being asked to go beyond the face of the judgment. And quite frankly, I don't think the judgment's intent is relevant. And the reason for that is there's case law that says that you can't have the judge testify to what he meant. It rules it improper for the judge to testify in motion for reconsideration. So why would that be improper if his intent? If you look at all the language, whether it's McCain v. Walker, which is from this court, whether it's Boynton v. Canal, all the language regarding that there is in court cases actually construing judgments is about giving the words of the judgment their latent meaning. It's the same thing for even contracts. We don't care what the parties thought. We care what the words suggest the parties thought. This is from the first restatement to the third restatement. People stop caring about the actual mental subjective intent of the parties because it doesn't put people on notice to care about their subjective intent versus the reasonable plain language meaning of the words they use.
Well, if we're going to plain language used here, and you're saying that there's no requirement to sell or no requirement to make the equalizing payment until after the sale. Let's say that's what the language clearly said, equalizing payment occurs after the sale. She sells the house. When does that payment occur? A year later, 5 years later, 10 years later? Any of that would be after the sale. How is that still not ambiguous?
It's not ambiguous.
Under your interpretation, he still couldn't enforce it even if she sells it because it doesn't say how soon after the sale.
Well,
anything is after. That's
true. But I think at a certain point after the sale of the property would be due, and then he would be able to move to enforce. He would be able to move to
Well, that's what they're doing now. They're saying they've already reached that point.
Yes, but the difference is it hasn't been sold yet. There's no language. If it boils down to ultimately, under the rules of civil procedure, if a judgment is going to require an act, it has to specify a deadline. So this judgment was fundamentally flawed when it was entered. And each party appealed. Each party had motions for a hearing. They decided to argue about a bunch of different things. For whatever reason, they didn't decide to argue about the main thing, that this judgment is fundamentally flawed, that it needs to specify a deadline if you think its point is to require a sale. Not only has this circuit required this before in that Schuler case, where someone was dispossessed after 20 years, wasn't allowed to force the partition of a property when they were granted half the proceeds in a dissolution because it didn't specify time. But the bankruptcy court for Orlando has cited this holding recently in a bankruptcy case where someone was required under a marital settlement agreement to sign over a note, but didn't state a deadline to his wife, and he didn't, and that note was considered part of the property. So the only case law that has existed on this has had inequitable results for the other party, and both this court and the bankruptcy court in Orlando didn't ultimately care about the equities. And at some point, you know, the rules have to be hard and fast enough that we can rely on them. And this idea of equity, we don't know, for example, that she's not going to get that payment. And as I argued to the trial judge, the survivor benefits, if she dies tomorrow, she never gets those survivor benefits, but they were added in the equitable distribution. That equally could have motivated the judge. You know, we could have the judge testify even though it's barred, so there's a reason why we don't do that. But there's many crazy theories we could come up one way or another about what the judge determined. Well, what the judge determined was that it wasn't to be sold until the sale date. And if we look at the language used, it is only capable of one interpretation. Lane ambiguities also require there to be that it's not obvious from the judgment itself. So lane ambiguity, which is more of a contract term anyway, there's a question about whether lane ambiguities can exist in judgments because I don't see much case law on that. They speak of ambiguities when there's more than one literal interpretation, but not lane ambiguities. But presuming that they exist for judgments, a lane ambiguity can't appear on the face of the document that's ambiguous, and it appears on the face of this that doesn't order a sale. So the proper remedy here was to address this in the direct appeal or in a 1.54 motion claiming either mistake, inadvertence, which could have been filed after the first person was supposed to graduate and that they would have moved to Virginia, or they could have filed one under intrinsic or extrinsic fraud claiming that she said she was going to relocate when she didn't, or they could have filed one under just the general inequitable provision, which is famously from the Terry Schiavo cases. Any one of those would have granted relief in a time period when he would have known. This is just, he sat on his rights and he allowed a fundamentally flawed judgment if it's supposed to order a sale date, but it doesn't from its plain language. And when you look at cases that deal with equalizing payments that aren't paid, all the cases before the court, for example, have circumstances where someone doesn't get their money immediately. In Roca v. Mendoza, the party is entitled to $270,000, but they have to wait till the guy retires. If they die beforehand, they never get that money. Their estate does. And DeSantis v. DeSantis, which is the touchstone case on that fact that you enforce your equitable distribution through creditor v. debtor rights, the person refused to pay the $7,000. They had multiple motions for enforcement. They just ignored. I guess they were judgment proof otherwise. They tried to attach to the retirement income. That was barred because of the homestead. The same thing in the Lawson case. In the Lawson case, someone didn't want to pay an equitable distribution. When we talk about this idea that there's been a reservation of jurisdiction, there's a case from this court, Encarnacion v. Encarnacion, that talks about this. And it says, after a final judgment is rendered, a trial court lacks jurisdiction under Chapter 61 to determine property rights, unless the final judgment reserves jurisdiction for a specific purpose regarding identified property. And that didn't occur here. Generally as well, courts are not allowed to alter property rights in a way that's inconsistent with the judgment. This judgment granted her possession of the property. Let's say that Mr. Gordon never signed that quitclaim deed. She could have recorded the judgment and she would have owned the Celebration residence. Well, it's inconsistent with that ownership to force a sale. And there's a Spencer v. Spencer case that deals with something tangentially related, where they had a list of everyone's property and then the judge entered an injunction barring one party from dispensing with any of the property, well, even if it was exclusively on his list. And then that was overturned by the appellate court saying, if he has ownership of this, you don't have the right to enjoin it because it's inconsistent with the right of ownership. And it's the same thing here. One of the most important bundles of rights, and the bundles of rights having to do with property rights, is the right to alienate or not alienate property. And that's, if she doesn't have that, how does she own it? It would be inconsistent. So if we're talking about clarification, but I do want to get back to this motion for supplemental authority. It's filed 2 days after the reply brief, and the rules very clearly state that it's not supposed to present new argument. They don't argue about the modification, clarification, distinction much in their initial brief or reply brief. And secondly, it's supposed to be case law that they didn't know by the time they filed the last brief. Now, I don't know how believable it is that after someone files a reply brief, in the next 2 days, they magically find a case that they feel is on point and then file in a supplemental brief instead of in part of their reply brief. And I think it's a way to skirt around the fact it wasn't included in the initial brief and require an argument that wasn't made in the initial brief. And by doing it in an oral argument, the court with the thought process behind it without the actual adversarial testing of it, because I'm now able to file a authority distinguishing it as clearly as I get the opportunity to at this hearing.
Anything further? Any further argument?
Does the panel have any questions that they would like me to address regarding either my briefs or my statements or how they apply to the opposing side?
Okay. Thank you very much.
Thank you,
Heather?
Your Honor, did I understand you to indicate that I have 4 minutes remaining?
Yes.
Okay, I need about 2, unless there are more questions. The former husband isn't the only party in this case that's relied on other portions of the record in support of their position. In fact, Mr. Weissman just mentioned the equalizing share being tied to the military survivor benefits. That is an issue that was previously litigated and resolved to the former wife's detriment. Both parties in this case have either encouraged or failed to object to consideration of the final judgment in its entirety. Now, Judge Fleming had no control over the significant disparity between the valuation of the properties in this case. The former wife wanted to live in the marital residence, which was valued at $600,000, and the Baldwin condo was worth half that much. The court was trying to do the right thing here, albeit inartfully, and it looks like a couple of opportunities to correct the problem were missed. But I believe this court still has the authority to eliminate the necessity for additional litigation and fix this problem now. The former wife continues to inflict financial injury on the former husband, places unnecessary burdens upon him without substantial repercussions. As far as the former wife is concerned, apparently this is a case of heads she wins, tails her ex-husband loses. I think the average layman in this case would say that this is an injustice based on a technicality. And I believe Your Honor has acknowledged by one of the questions to opposing counsel, this situation appears to be unfair, and we believe it is. I'm prepared to address the concern by opposing counsel with regard to the notice of supplemental authority with the Rule Act decision if the court has any concerns about that.
Now, we'll go ahead and conclude then.